and welcome to Legally Speaking with me, Tarun Nangia. Justice Vikram Nath and Justice Rajesh Bindal of the Supreme Court of India have issued directions or certain guidelines, as they have said, on bail applications. Some very interesting suggestions have come from their side, which will now be implemented at the High Court level. Also, why these guidelines are important, how will it help bail jurisprudence, all of this and more we will get to know from our panel today. May I welcome Senior Advocate Geeta Luthra. Good to see you, ma'am, again, and looking for some interesting and insights from you. Today, I have with me Justice Raghavendra Chauhan, Sir has served as Chief Justice of Uttarakhand High Court and also joins us on this show today. He also previously was a leading lawyer on the criminal bar side, and so, of course, he will have much to contribute from both his experiences. Good to see you. At the outset, may I request Justice Chauhan that in the next 2-3 minutes, if you could make some comments on these directions issued by the Supreme Court judges, namely Justice Nath and Justice Bindal, before we move on to the discussion.
Number one, this problem that has been noticed by the Honorable Supreme Court in this case of Koshar Duruka versus State of Odisha, it's a problem that I think is quite frequent and inflicts most of the high courts. We in Rajasthan had similar problems when bail petitions, which may be second or third bail petitions, do not indicate that a previous bail petition has either been dismissed by the Honorable High Court or an SLP has been filed, which is pending before the Honorable Supreme Court. And this creates a lot of problems and creates a lot of embarrassment for the High Court, because the Honorable Judges of the High Court do not know, in case a bail were rejected by a single judge of the same High Court, unknown to another bench of the same High Court, there could even be contradiction. While one bench tends to grant the bail, the other bench may say that I refuse to grant the bail. Therefore, I think these directions issued by the Honorable Supreme Court are extremely important. They're fundamental to the criminal justice system. The sooner we implement them, in those high courts where it has not been implemented, I can assure you that in Rajasthan, we have implemented this many years ago, where the rule is that all the bail applications arising from the same FIR will be listed before the same judge, number one. Number two, you have to give an affidavit as to which bail number it is. If it's a bail, fourth bail, you have to indicate the history, summary-wise, a history of what happened to your first, second, and third bail applications, dismissed by what order, dated what. So the registry in a position to connect all those other files. But it is not to suggest that it's a foolproof method, because lawyers can be quite clever, and registry at times may inadvertently make a mistake. So I think these are very important guidelines for all the high courts to follow. Besides this, the other judgment that has recently been pronounced in the case of Rajanti Devi versus Union of India by Honorable Ms. Justice Bela Trivedi and Honorable Mr. Justice Satish Chandra Sharma, I think they too are very valid and very important for all of us. They've said you must decide your bail applications as expeditiously as possible.
Okay, point very well taken. I'll go to Senior Advocate Geeta Luthra. Ma'am, at the outset, if you could please make your initial comments on these directions, then we go to the specific questions.
So I think bail is affecting the liberty of an individual. And that's why every judgment which comes from the Supreme Court, which has general directions with regard to bail and grant of bail by the High Court, has enormous repercussions and therefore has great deal of importance. For a person who is sitting on the brink of liberty and who's been facing the ignominy of being in custody, there can be nothing more imperative then grant of bail or consideration of his bail. So these directions, while they try to ensure that they, in a particular case arising out of an FIR, the matter would be heard by the same bench, it still obviously cannot obviate the obvious aspect that even in identical fact conditions, the mindset of a court may be to grant bail and to give that, as they call, the concession of bail to that accused, or maybe not to give, even though, because nobody can go into the fact situation being similar. So in one FIR, and therefore these directions are very welcome, but of course with this caution that to ensure that there will, in all fact situations, be similar orders is not something which the court did and is not something which is possible also.
Okay, point very well taken. We now one by one quickly go through the guidelines. First, number one, it says that details and copies of earlier bail applications should be submitted before the court. Secondly, details of any other bail applications filed by the petitioner pending in any other court, that also should be submitted. Thirdly, it is also very interesting that they have told the registry to attach a report generated from a system about the decided or the pending bail applications. Here I'd like to get Justice Chauhan in that the registry also has been given directions. What do you feel that this will have an impact all over India in all high courts, that now registries of all high courts will have to attach that, and how easy will it be to do it?
No, I think now that we have information technology introduced in most of the registries and most of the high courts, I don't think it's such a difficult task these days. Of course, in the olden days, when you did not have the availability of computers, of softwares, you did have this difficulty. But for example, from my experience in Rajasthan High Court, it can easily be seen as to, if you type in the FIR number and the police station, the computers will pull out all the bail applications which have been filed with that common FIR and the police station. So it's almost at the click of the button now. And I think the more you introduce artificial intelligence into the judicial process or into the judiciary, I think it will become a very easy task. So I'm so glad that we are involving the registry, because they play a pivotal role in movement of the files and ensuring that all the files do reach the respective courts. But what I also like is the fact that in the last direction given is that the duty of the IO or officer in charge of the case to assist the public prosecutor. I know it was about a decade back, it was done by the Madhya Pradesh High Court, where they did have this system that the moment an FIR is filed by the police gets in touch with the person who is the public prosecutor and gives him the complete facts of the case, and even gives him the antecedents of the offender, which is very good, because even that antecedent of the offender plays a vital role in deciding whether bail should be granted or not.
Okay.
So that information is very germane to the decision of a bail application. So I'm so glad that this point has also been included. And although it is restricted to whether earlier or pending bail applications arising from the same FIR, that information, but I hope it also includes that the IO will brief the public prosecutor as to how many other cases are pending against this particular accused.
Point very well taken. I'll just repeat the point number 3 of what you can say, the direction that the registry of the court should also annex a report generated from the system about decided or pending bail applications in the crime in question. The same system needs to be followed even in the case of private complaints, as
Yes.
all cases filed in trial courts are assigned specific numbers called CNR numbers, even if no FIR number is there. Very interesting. I'll go to senior advocate Geeta Luthra for her comment on this one.
So again, something which has become a norm and a practice in most high courts. In fact, the court observes that perhaps in Orissa this is not being done, but it is the practice in most high courts. And usually the attempt is, and even lawyers assist in this, even the prosecution assists if by chance the system, the registry, and the computer misses it. So the computer always says same one FIR case assigned to court X. Then other aspects of the case, normally if the roster permits it and if that court has the jurisdiction with the other, with regard to the other issue which may arise out of the same FIR, it may, to have a holistic dealing, it gives it to that court. So this is normally the norm in most courts in any case. Now question is that you have to delineate and describe. I'm thinking from the viewpoint of a defense lawyer, while there has to be transparency, and while we should be talking first, second, third, fourth bail application, let me be the devil's advocate. Every day of grant of being in custody is a fresh ground. That's what the law says. So while we have to be there in disclosure, if the disclosure is so over elaborate, then even if you are coming 3 months later, that disclosure should not affect your right of bail, because ultimately, even if you are there for 5 extra days, 2 extra days, every one of that aspect is a fresh ground. I'm not saying there won't be transparency. Registry is already looking after this. Sometimes these anomalies happen, and that was noted in the earlier case which is being referred in this, which is that Pradhani Jani case, which was Justice Gawai's bench's decision. And this has been elaborately given with the guidelines, because these anomalies are noted. Now, the registry has to be careful, that's a given. In most cases, registry already has these directions, the software already picks up this. And insofar as what Justice Chauhan has said, I don't think Rajasthan is an exception. All of them, earlier, the provision, the way it used to be done, say 15, 20 years ago, state filed a counter affidavit. Clearly, the IO has to help and give the inputs. Now, what has become prevalent, and I feel slightly sorry about this, is that we give a status report. Now, a status report is not an affidavit. If you say something on affidavit, see, the accused and the petitioner is saying something on affidavit. Affidavit has some solemn meaning to it, even if it's through himself or the pervocar. So I feel the same is should be the requirement, was always the requirement of filing counter affidavit. Now, somewhere this system came just to expedite matters because the state was taking time and bails require urgent treatment, that you just file a status report. Status report, I feel, doesn't have the same solemnity. Sometimes a statement is not made as seriously, but does the IO need to help? Yes. Immediately, for example, in Delhi, then the moment an advance copy is given, they try and inform the police station or the investigative agency concerned so that they can be there. Sometimes you don't get the input on the first day, and then the court says, okay, we'll put it on another day at an early date because it's a bail application for a status report. And I feel it should be a counter affidavit to be filed where the investigating authorities officers' inputs are always taken by the prosecution before it takes a stance. So I believe that this is in place. What has been done is to streamline so that all high courts will ensure that this is done.
Point very well taken. Of course, you mentioned the point, but I'm going to again read the last point of the guideline, that the duty of the investigating officer and any officer assisting the state counsel and court is to apprise him of the orders, if any, passed by the court with reference to different bail applications or other proceedings in the same case. But very interestingly, the court said that the counsel appearing for the parties have to conduct themselves truly like the officers of the court. Very interesting statement to be made by the two honorable judges. Over to you, Justice Chauhan, for your comment.
I think that's a subtle way of acknowledging that perhaps some of the lawyers are now deviating from this assigned role. And I think it's high time that I think periodically we need to remind our counsels, not that the counsels are bad, but as you see that there is a lack of training and lack of adherence to the good practices of the system that we have maintained for over ages. So I'm glad that even this has been reminded that please remember that you are first the officer of the court before you become a lawyer of a client. And I think that's very, very necessary on both the sides, whether you are a public prosecutor or whether you're a defense counsel. Both must remember that they're there to assist the honorable judge reach the truth. And therefore, there's no point of either the public prosecutor hiding things, which may be in favor of the accused. He should be frank enough to say, yes, there are things which are in favor of the accused, and certainly the counsel for the accused, the defense counsel, should be open to say, yes, this is how things stand, and then try to argue his case for a bail. But Tarun, to me, what is most important is that despite all these guidelines being given by the Honorable Supreme Court repeatedly, I mean, we have been having these type of guidelines since 1976. The question is why there is a delay in decision of the bail application, especially as Ms. Luther rightly pointed out, when you're dealing with a bail application, you're dealing with Article 21, the liberty, the personal liberty of that person. So why this delay and constant delay? And I think that is where one has to see what is the malice there, what is the remedy for that illness. And that is where we have to focus upon. The rest of it is merely symptoms that we are looking at.
Point very well taken. We will now move to the round of closing comments where we sum up the whole guidelines that were issued by Justice Vikram Nath, Justice Rajesh Bindal. I'll go to Senior Advocate Geeta Luthra for her closing comments on the show today.
I like that last line, which you just emphasized, that we are to remind ourselves that we are officers of the court. And sometimes of course, this malice may lie both with the petitioner who's seeking bail as well as the prosecution and the state that is becoming overzealous. But I always feel that the state has to have a word of caution because the petitioner has a personal stake. The state has a duty to the court, to the public, and to the law and order in the country. So the state should not become overzealous. It has to be honest, it has to be genuine, but it has to be dispassionate. And I believe that this reminder to all of us is a kind reminder, and we have to keep this in mind. We also have to keep in mind that time and again, the Supreme Court has said, don't use bail as a tool. don't use refusal of bail as a tool. We may be having a very delayed system, but justice doesn't mean that if I keep someone in custody and therefore thereafter acquit him after 10 years, I have had my pound of flesh. That's not the pound of flesh that we want. While we want the justice delivery system to become quicker, bail has to be decided on merits without looking at the fact that because of delay, let's keep this person in for another 2 days or even another hour. So that's the only closing comment.
Thank you. Thank you for the closing comment.
Honorable Supreme Court was shocked in the case of Rajanti Devi when bail was kept pending for a year. And I'm sure it will shock anyone to know this fact. I agree with Ms. Luthrop. Bail, like habeas corpus petition, have to be taken, as expeditiously as possible. You cannot keep a bail application pending for months on end. Now, the question is that one of the reasons why we have this difficulty is the large pendency of bail application in each high court. For example, in Patna High Court, I'm told there are 6 benches that are exclusively devoted to hearing bail. Something is wrong with our system. Why is the district judiciary not fulfilling its function under CRPC? They have ample power to grant bail, but unfortunately, at times you'll find that district judiciary is so demoralized that they're frightened to grant bail. Again, I'm sorry, I keep on referring to my experience in Rajasthan, but in Rajasthan, there was a time when we used to tell our judicial officers not to grant bail. Now, the moment you have that way of training your judicial officers, A, all the bail applications will eventually reach the High Court. B, even those who are coming from the service side will continue to have that mindset. They will not grant the bail. So the matter then comes to the Honorable Supreme Court. And I think that's playing havoc with the lives of the people, because we must understand that Constitution is our guiding principles. The constitutional values are our values, and liberty cannot be compromised until and unless the law says that. In NDPS, yes, it's understandable. PMLA, it is understandable because law is strict. But as far as the offenses under IPC, I see no reason why bail should not be expeditiously decided and be granted.
Point very well taken. Thank you for joining on this show where the guidelines issued by Justice Vikram Nath and Justice Rajesh Bindal were discussed. Very important for the Supreme Court also to give guidelines from time to time, because the message also needs to go to the High Court and the district judiciary. We've seen other judges also have done such earlier, but it goes on to show that the Supreme Court cares, and also for liberty and also for justice, which should be done in a manner where it's seen to be done. That's why the registry being directed to submit this report is also very important, because the judge should be rightly apprised of the true situation. Otherwise, how are they to decide? But thank you so much, ma'am Geeta Luthra and Justice Raghavendra Chauhan. You all made time and joined us on this interesting show. Thank you so very much.
Thank you, Tarun. Thank you for inviting us. Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.